I do apologize for the kind of throaty voice I've got today, but I'm hoping it's going to warm up as we go, and it should be just fine. I am so privileged to be here, and I wanted to thank Mary and Claudia and the whole program for having this conference and for really giving me the honor of being able just to participate. I have learned so much just in this morning time together already. So let me kind of give you a little context of how I come to be here and the kinds of things that I hope to talk about in the next bit of time. So 14 years ago, I went to law school, and I was just a baby social worker and a community organizer who had done a bunch of work in different rural places on community development and youth issues. And I thought, I'll go to law school because I want to make the world a better place, and I think the law is a great tool to do that. And then my first summer of my law school career, I did an internship. It was work in rural America on land tenure issues, which I saw a sign and it sounded great. And I ended up working with an Indian probate judge in Bismarck, North Dakota, doing probate hearings with the tribes in North and South Dakota, Judge George Tawbone, who was a great influence for me. If you know him, some of you might know him as well. And Judge Diane Johnson was in that office as well. And what I saw in that first summer of law school as just first a baby social worker and then a baby law student was an example of where I felt like the law was doing direct harm, that the law was actually not so much a tool to help, but instead was really directly and immediately having adverse consequences for the people for whom we were trying to serve. And Judge Tawbone was a great mentor. That was back in the days when Interior was offline for the Covell lawsuit. So I remember fondly riding my little bike down the hill in Bismarck, North Dakota to go to the public library so I could research what intestacy meant and what probate meant and how various statutes worked. And I would sign up for my 30 minutes of time at the public library, and that's how I did my research and learned a lot about probate, but also about Indian land tenure. And Judge Tawbone always hit home the importance of really understanding a problem before you try to solve it. And that the fractionation problem, the land tenure problems, were much more complicated than they even first appeared. And that if you sort of kept peeling that onion, it would become more and more complex. And so I have spent a lot of time since then thinking about the problem, and I can tell you I still don't, I'm not sure I fully understand it yet. It is tremendously complex. And so I'm really privileged and humbled really to be here just to present probably more questions than answers. And I hope that we can do this kind of in the spirit of a conversation. So I'm a recovering lawyer now. I went on to be a lawyer, and I represented Indian interests and clerked in tribal courts and did lots of different things. I'm recovering from the practicing lawyer world, and now I'm a law professor. And if you know how law professor or law classes run, I'm used to cold calling on my students and sort of making them scared, not intentionally, but that's part of the process. And so I don't intend to cold call on any of you, but I would welcome questions as we go, and I really hope that this can be an open conversation. And what I want to say is that I, of course, am only speaking through my own lens, which is extremely limited. I am an outsider looking in, asking questions. And so everything that I say is in the spirit of suggestions, questions, musings. I'm not dictating or even suggesting one solution or the other, but instead, as I said, just kind of gentle musings and in the spirit of a conversation, some things that I, as a person who thinks a lot about property and a lot about land tenure, things that I've thought about or am thinking about. And I am, as the title suggests, this is what Mary and Claudia sort of asked me to talk about too, but it's also consistent with my general research agenda or the sort of general work that I'm doing now, which is I absolutely think that consolidation is essential and important, but I also think that there's much more to the issue and much more to Indian land tenure than only thinking about fractionation and only thinking about how to consolidate those interests. There's this much more integrated property system that's really at issue, and so what I want to do is kind of think about that broader system and talk about that a little bit. Now, here's what I would say when I sort of go to talk at law professor conferences or things, or just talk about Indian land tenure, or other people talk about Native American land tenure. I think we have sort of general boxes that we would check of these are the things that are problematic, right? Everyone sort of talks about what's wrong with American Indian land tenure. And so one of the things, or one of the challenges at least, of course, is the fact that the trust status is cumbersome. It is bureaucratic. There are lots of additional transaction costs and steps and things that a person has to do in order to make use of or do anything with their trust property that outside of the trust context a landowner wouldn't have to do. So that bureaucraticness, the restrictions on alienation, obviously those have pros and cons, but they're part of the challenge of the system. And then, of course, fractionation, which we've talked a lot about today. We all know the statistics. We all know how complicated that issue is. And then I also think that the third thing that we kind of typically tick off as a reason for concern or a challenge or a thing we worry about is this jurisdictional checkerboard. It's the fact that although indigenous nations, of course, historically had territorial jurisdiction over all physical spaces within their boundaries, the Supreme Court, the law has not evolved in that direction, and now we have this much more piecemeal jurisdictional framework, which affects land tenure, land use, and governance much more broadly than that. So when we start here with the kind of classic, this is what is wrong with American Indian land tenure, these are what the challenges are, well, we're already assuming that there's something that's awry, right? That there's something that has gone awry. And I'm not contesting that that is not, in fact, true. But more precisely, I want to kind of challenge this first part of the conversation to think about by what metric do we know that things are wrong, right? Why are things wrong? And if they are, what would we want instead, right? What's the goal of a property system, of a land tenure system that we would pursue in lieu of the challenges caused by this current system? What do we want to have? And so what I want to talk about today, I'm going to group into kind of three categories of things. So one, I just want to talk about, this is pure property professor, sort of my favorite thing to talk about. I just want to spend a little bit of time talking about property systems and what they do and what their functions are and why they're so important and how they are designed, right? What they are designed to do. So that when we're thinking about what's right or what's wrong, we can compare it to what do other property systems do? What might we want a property system to do? So kind of setting that goal. And then again, on this theme of kind of looking at the whole land tenure system, the whole property system, not just fractionation or just alienation issues, but at the whole system as it works together. I have three examples of things I want to talk about that I think show how integrated these issues are, and they're kind of wrinkles that maybe we don't think about as much. So sort of additional land tenure challenges or nuances to the land tenure challenges that relate to consolidation, but that I think we need to talk about kind of all in a collective conversation. And then finally, I want to just very sort of tentatively move towards next steps and thinking about not what's the solution necessarily, but more of what's a process by which we could achieve solutions, or what's a process by which, if we think that this system does not fit the goals of a property system in the way that we would want it to, what's a system or a mechanism of going about making some of those changes? Kind of how does that work? And that's an area that I'm kind of just tentatively beginning to do some work in, looking at other societies and cultures and countries where land tenure has changed dramatically over time and thinking about transformational property and how it happens. So I'm got sort of very tentative. This is all tentative, but especially at the end, I'm tentative about, here's kind of some initial thoughts that we can test out together. Okay, so starting first with kind of why property matters. I think in order to do that, we should also just kind of put consolidation in context. And so none of this is new, right? This is kind of just laying the context for what I want to talk about next. But I would say if we think about efforts to consolidate fractionated allotments and individual trust property, we basically have four categories of strategies or approaches that exist now. And they're all incredibly important. I'm absolutely not dismissing anything about the importance of consolidation. But I do, this also, we all know this, consolidation is really hard, right? The likelihood of getting to a point at which we have complete consolidation, whether that means sole ownership of parcels by individuals, more tribal ownership, however we define that, getting to that point is challenging. And we've seen that, right, by lots of generations of effort to try to re-aggregate fractional interests that have become subdivided. And so we've got probate reforms. We know APRA and the penalties essentially for making decisions about your property once you die that don't consolidate property. Estate planning. Now those of course primarily exist to slow the rate of future fractionation, which is important. It's obvious, but I think it's important to have that context that even at their best, probate reforms and estate planning will sort of freeze us in terms of the number of co-owners. Now there's exceptions, of course. APRA's got purchase options, things like that are actual active aggregation tools. But probate and estate planning, and even a lot of the individual actions like gift deeds and things like that, some of that is consolidating, but a lot of that is just kind of keeping us at the status quo, which again, super important, but does not actually consolidate interests. And then we've got tribal land exchanges and, of course, the buyback programs, which are also valuable. And we know the experience at Rosebud, which the process has taken a really long time. That's been a disincentive for some landowners, but they have managed to consolidate with tribal exchanges significant amounts of property. So that's valuable. And then, of course, the buyback program is ongoing now. I want to give a couple of kind of additional thoughts just about consolidation. One, so this is entropy in property, which is a theory in property law, but it's just kind of a way to talk about this thing that we all experience, which is that one thing that we're working against when we work for consolidation is the fact of life that it's simply easier to subdivide and fractionate property than it is to consolidate it. And so if we were thinking of this as a physics problem, which I am horrible at physics, so I shouldn't even sort of use that word. I'm like not even entitled to use the word physics. But if I did, I would say that the idea is that sort of property interests move towards smaller and smaller size of interests, move to fractionation. Reassembling them is difficult, and you have to work against those forces. And so this is also true so that we should also keep in mind that even when we do get things consolidated, of course, this force is going to work against us again, and in future generations make sort of maintaining consolidated ownership hard. So one thing that sort of property law outside of the American Indian land tenure context or outside of Indian country, one thing that we check about is we look for things in property that exist as boundaries to prevent fractionation. So if we were outside of the trust land context or outside of Indian country, things like having to record small interests, of risks of partition where you don't have alienation restraints or partition restraints, property tax being imposed on tiny interests. At some point, the cost of those things outweigh the value of tiny interests, and so people consolidate because the incentives work to align in order to encourage consolidation. Those are boundary ideas. Now, one thing about American Indian land tenures is for good reason, but some of those same boundary principles don't exist, which again, for very good reason, I'm not contesting that. But in Indian country, there are kind of even more incentives for fractionation to occur that we're sort of working against. Now, let me just give some depressing numbers. So Thomas Stratman couldn't be here, so I'm going to give his stick for him, not really, but I'm just going to sort of summarize a couple of his statistics from, he's written, I know of at least two significant economic pieces about Indian property. One is in the folders, and the other one he's written is Creeping Normalcy, which looks at the rates of fractionation over time. And so he compared, so in 1992, the Government Accounting Office did this study of 12 sample reservations to get at some statistics and numbers about the degree to which land tenure is fractionated. And it showed it was pretty bad, right? And so that led to some of the Indian land consolidation amendments, various efforts to try to encourage consolidation of this really fractionated land base. So that was 1992. Now what Thomas Stratman and Jake Russ at George Mason did was they got data from BIA for 2010 for those same 12 reservations and tried to compare after decades of effort to consolidate interests. So how have we done, right? Have things gotten better? And so this data shows that basically entropy at work, that fractionation continues to go at exponential rates faster than we can make it stop. And that makes sense because it's easier, of course, to fractionate, right, than to consolidate. And so, again, this is depressing, but we'll just get them out and kind of move on. But fractionation roughly doubled at those 12 sample reservations in that 18-year period. The rate at which interests are getting fractionated increased from 1992, where it was 35,000 new interests per year, to 44,500 new interests per year in 2010. This one might be the most sort of concerning, is that even just looking at not the number of interests, but the number of parcels that go from being in sole consolidated ownership to a co-ownership state, that increased 21% from 1992 to 2010. And just on these 12 reservations, the cost of record keeping increased fivefold. Now, I'll just sort of one more caveat, or sort of statistic, I guess, to get out, is, of course, the buyback program, fairly, and it's a voluntary purchase program. It's not designed to transfer all ownership to tribal interests. But, we should be clear that the program is not designed to completely consolidate, right? There isn't enough money. Not everyone will willingly sell. We're not going to get to the point of complete consolidation. I am such the downer, I know. This is like, I'll just come up here and kind of be the jerk that says the consolidation, it's really important, but it's a hard battle. We are in an uphill battle to try to consolidate interests. Now, so the reason that I am kind of positing this as beyond consolidation is that a general kind of idea is that if we accept that consolidation might happen, we might reduce the number of overall interests in fractionated parcels, we're not going to get all the way there. We're always going to have some degree of co-ownership. And so maybe we should focus we should ask questions about, is there a better way to make use of what we've got now? Is there a better way, given co-ownership, given fractionation, to continue to focus on consolidating those interests, but at the same time to be working on ways to make those institutions of co-ownership more meaningful for landowners, more useful for landowners? Now, I have this kind of big language up here. This is kind of my touchstone for the talk, and I want to just talk about it for a bit. So in a way, that's what I just said, right? That consolidation is one thing. There's also the issue of function. There's also functionality, usability of property institutions and those are not necessarily the same thing. But I don't want to give the wrong impression, because consolidation and functionality or usability or rationality of a co-ownership, fractionated ownership status, they're very much related. So as we consolidate fractionated interests, of course, the number of owners go down and the assembly costs, the coordination costs are reduced because you have fewer co-owners you have to negotiate with or coordinate with. So consolidation certainly assists with functionality. Now, I would also argue that functionality actually assists with consolidation, because if you think about it, if I'm a landowner with a very small fractional interest, and I have maybe a couple of very small fractional interests, my incentives to consolidate those interests into a more usable interest size, a larger interest size, my incentives are dramatically greater if I perceive that once consolidated, my ownership is going to be in a status in which it's usable to me, or in the status in which I desire. And so if the sense is, we have all these problems with American Indian land tenure, the whole system is so hard, I think we need to ask a hard question about why are rational landowners wanting to consolidate? And of course there's good reasons, but we might make those reasons even better if what we promised was a fully functional property system. All right, now, okay, functionality, that's a nice word. Law professor, outsider, I can just talk about functionality, and what does that mean? And now we're kind of at my first part again, which is, what's our goal, right? What does functionality of a co-ownership institution mean? If I'm going to co-own my property, what's the goal? What does functionality mean? And now I just want to give a little sort of context about at least one approach to thinking about that. Now, this is from my tradition as a law professor, as a legal scholar. There are lots of other ideas about the ways in which property functions. I'm just putting these three up here, my own sense, as kind of conversation starters, right? Just to be stimulating, not to be excluding or exclusive of other perspectives of the role of property. But in property law, generally, we think of three categories of reasons in which we have property systems. So we could have no system of private property. We could just have free range. People take resources as they find them. We could have all government ownership. We could have lots of different types of structures of ownership. But the reason that we usually think of having individual ownership or some system of private property, there's this idea of liberty, which is the idea that property exists to be my buffer from the government. So property, as a private property owner, it's my sense of autonomy, it's my sense of this is my keystone right that makes me kind of free from government interference in this space of great autonomy. Right, now that is very different from trust land. Okay, we should just acknowledge that at the outset. But that's sort of one justification of property. The other is utilitarianism, which says we have property because it facilitates market transactions. So property is the currency of our market. We have private property because it is an efficient way to organize our entitlements to resources. It makes us make better decisions for the future. And it's about that metric of economic efficiency. That's why we have property. Now, there's a growing school of property thought that has different names. It can be called progressive property or human flourishing or just the social notions of property. And it says property is not so much about individual liberty or rights or economics, but instead we have property because it organizes us as a society. And so because we have property, the nature of our property right entitlements, it reflects our values about how we relate to each other with respect to resources. It reflects our values as to how we connect with the land and the environment and the world around us. And it impacts both owners and non-owners. And so in order to be a just property system, it should be designed not only to benefit the owners, but to be fair and equitable to everyone in society. And we can only justify it if it's moral in that broader way. Now, I don't know which one of these is right, and as I said, there are other possibilities and ways to think about just the very fundamental question of why we even have property. And of course, I can't kind of talk about this without talking about, of course, there were indigenous notions of property that I wouldn't presume to speak of before contact, before reservation systems. But we also should acknowledge that this whole system came from allotment, which was absolutely a property experiment by the federal government who said, let's tinker with indigenous property systems, with whatever systems of allocating rights to resources, relationships to land existed, and let's just impose a different property system specifically for social engineering, specifically to cause changes in the social, cultural, political, economic lives of indigenous people. And so the designers of allotment thought that property was transformational. They thought that property was powerful and that it reflected very important values. Now, what I would argue is that the things that were the leasing regulations, the right-of-way regulations, fractionation, trust status, alienation restraints, those are all the exact same things. Those are top-down federal decisions about how property relationships are organized in Indian country. And it's not with the express assimilationist social engineering purpose, but it might be doing some of the same things, or at least having some of the same effects. And so part of my pitch, I guess, is to kind of encourage us, indigenous nations, indigenous people, to think about the power of property and whether the system, this top-down system, actually reflects what you want it to reflect, or if there are ways to change it to reflect something that you want, and how transformational it could be. Now, another way to frame the sort of three very academic approaches to what property does is to just think about the difference between construing property in a sense of rights, a sense of individual entitlement and autonomy and economic returns, as opposed to thinking about property as a way that constructs our relationships to each other. And when it constructs our relationships to each other, obviously it's our entitlements to resources, who gets to use them, who gets income from them, who can alienate them, how do owners and non-owners have responsibilities to each other if they do. But also individual and group identity becomes tied to property. If you think about various countries in the world, often we can define a lot about that society by the way their property systems are structured. So property is kind of the going concern of how a society is organized. So this individual and group identity, obviously connection to place has a whole special component here. Land ethics, actual what the rights are to use real property, other social values or other types of values, and then this idea of kind of enfranchisement, right, that it encourages a group, kind of a working togetherness. So this is vastly oversimplified, but one way we might frame this is rights in the sense of, again, individual entitlement, economic values, which is super important, right? Personal wealth generation, personal wealth accumulation, individual liberty to make choices about a resource, the empowerment. I mean, that's all critically important, and that would be kind of in the rights ledger. And then the relationships is more about sort of how we connect with each other, right? So how we design our physical spaces, how agricultural land gets used for what purpose, who shares in those benefits. Interestingly, this picture here under the relationships side of the column is actually close to my home. This is the Ho-Chunk village, which the Winnebago tribe in Nebraska decided to build a town from scratch. They didn't have enough housing on their reservation. As many of you probably know, doing pretty well economically. Ho-Chunk Inc. has had a lot of really kind of amazing economic development, pretty diversified economic development. And as part of their sort of whole process of bringing people home, improving housing, improving quality of life, they decided to build a town. And the process of building a town from scratch is quite amazing because you get to ask questions about, should there be common spaces? What should those common spaces look like? Is there, special traditions that should be reflected in the way those common spaces are organized? Are there spiritual significance in places that need to be protected or cared for? And how do we live to each other? Do we have our private yards or our yards open for our children to come across? Do we live in family groups? How do we do this? So this is what Ho-Chunk Village did. And it's still very much being built, but this is what they designed. Now, this is on the Winnebago reservation, but I don't think it will surprise many of you here to know that in order to do this, they had to do it on fee property. So this is all on tribally owned fee land in the reservation. They didn't even want to bother with trying to do this on trust property. And I can't speak for them, but it is on fee land, and that was a conscious choice, I'm sure, in order to have a more usable system of property in which they could build something like this. Now, here's a quote that I like a lot from the Crow chairman about a land hearing, but he was talking about kind of the whole American Indian land tenure system, this problems with fractionation and trust status and jurisdictional confliction or conflict. And he says, so what we've got now, this regime is not tribal or communal ownership, but a chimera created by federal policy. And a chimera, of course, I don't know if this is actually one, but the Greek mythology, right? This kind of strange beast with different parts of different animals mixed together. It's also kind of illusory. It's a synonym for things that are illusory in some way. And I just don't know that is the analogy I would want for my land tenure system, right? That this is the kind of property system that I've got. Now, again, here's where we started with trust status, fractionation, jurisdictional checkerboard. At least one person's called it a chimera. You can have different views as to that. But what I would challenge us to kind of think about and how I want to frame this is does this system reflect what in the rights and relationships that is defined by Indigenous people in a way that Indigenous people want their relationships to be defined and their rights to resources to be defined. Now, what I want to do is focus on fractionation. So I'm going to go through my 3 kind of examples of where I think a broader picture as to how these property systems work could be informative for next steps and for creating a more rational system. So let's focus on fractionation because that's clearly, we spent a lot of time talking about that. Now, we think about fractionation differently, and I want to think about it differently. I want to think about it not just in the context, again, of how can we get rid of it, but also to the extent there is co-ownership as a status of land ownership that persists, how can we make that co-ownership work? And I don't have the answer, but I have some good questions. So here's sort of how I would frame this, and I was talking about this with some of you earlier too, but so here's kind of the baseline. So as property people, as a property professor, I think about co-ownership. I'll start here and go back to the other side. I think about co-ownership, sort of the default rules that define who gets what rights to a shared resource. Those default rules, I think of them as being very significant and being designed for explicit purposes. And so the question is, how do you design the rights of co-owners with respect to each other and with respect to the jointly owned resource so that it impacts outcomes in the way that you want it to, so that it encourages cooperation, if that's what you choose, so that it encourages efficient use of resources, if that's what you choose, and who gets the priorities to make those choices. Now, just as a comparison, I want to just talk very briefly about how tenancy in common or co-ownership works in most state law outside of Indian country. Not that this is the right way by any means, but that here's a model of a different way that co-ownership works. And so here are sort of baseline, this is how a tenancy in common would work, sort of key principles. So first, and what I tell my students most important, is that the key aspect of a tenancy in common is that every co-owner has a unity of possession. And so even if 10 people co-own my property in Nebraska, all 10 of us have the same, no matter what our interest size, we all have the same right to possess the whole. It's a core attribute of ownership, of property, and it's that unity of possession that defines co-ownership. And also in the traditional tenancy in common law outside of Indian country, the co-owner who is in possession has no obligation to pay rent. So that's just part of exercising your right. As a co-owner, you get to make use of the property. Now, co-owners do have responsibilities to each other. So there are default rules, for example, about how you allocate repairs or maintenance, or if someone wants to make an improvement, who pays for that. And there's also, in this third bullet, mechanisms to resolve conflicts or disputes. And so certainly when you've got 2 people or 10 people who all have the same right to possess the property, there can be a conflict when more than one person wants to possess it because you all have the right to possession, but not in a way that infringes on your co-owner's rights. And so there are all these doctrines, things like ouster, where if you actually physically kick another co-owner out, then you do have to pay them rent. You have to pay them fair market value rent. There are things like waste, which says if there are different co-owners who are in dispute about the best use of the property, there are doctrines in state law that tell us about how those priorities are set, which user gets to make that choice. And then the other key attribute is that every co-owner has an absolute right to exit. So every co-owner gets to sell their property at their own election, and they could either sell their interest into someone else who wants to come in and be a co-owner with the other co-owners in the property, or they can force a partition. And a partition here means go to court, file a very easy form, say you want to partition the property, and you have an absolute right to exit, because one of the values reflected here is this sense of autonomy that no one should be tied into co-ownership with people they don't want to be in co-ownership with. And so you can either get a partition in kind if it's feasible, where the court will physically divide up the property, or you can force a sale of the property. Now, When I was a Skadden Fellow forever ago, I worked with farmers. I worked with farmers and ranchers across the country on lots of different issues, but especially on land tenure. And one of the groups that I worked with quite a bit were African American farmers in the South, and groups like the Federation of Southern Cooperatives and the Land Preservation Project. And there, I think it's kind of useful to think about the fact that this is another area in the country where we see really high degrees of co-ownership. So Indian fractionation is not the only example in the US of high degrees of co-ownership, but the experience here is very different, and I think it's worth just reflecting briefly on why and how it's different. So it's prevalent in African American and Appalachian families in the South and Southeast for similar reasons. So generations of intestacy, where there's relatively small amounts of wealth in the family, the ability to access probate. So in many instances, there have been generations that have passed, but the property's never gone through a probate because the landowners have to go and actually do that. They haven't recorded their interests. And so it becomes called heir property, where you have a lot of sometimes even unsettled, unknown owners. Now, the experience there is totally different, and I should tell you, it's still problematic. But what we generally see, and just speaking in generalities, when we are thinking about this high degree of co-ownership with heir property in African American or Appalachian or other families, there's this high degree of insecurity of title, and so the risk is land loss, which is not something any of us want to see broadly in Indian country or beyond. But so these people have, there's a high degree of insecurity in title and land loss because either one co-owner will force a partition and then therefore the property gets sold, or even more often, I think, there will be a tax foreclosure where the state or local government will say, we want tax on this, no one's paying it. There'll be a foreclosure process, and then the co-owners don't have the money to pay it or redeem it. And so property ends up getting lost, and that's the real kind of risk. And so there's been some reform efforts. There's been focus on how to make title more secure in these tenancies in common. But the big benefit, and at least what landowners I often hear is a benefit, is that there's also, because of the unity of possession, because of the informality of the co-ownership rules, there's a high degree of informality, flexibility, creativity, where landowners make direct use of their property because it's their significant asset, build homes, build multiple homes, live together in families, and have a real tie to this space. And so the asset is tremendously valuable to these families as a place of flexible use and connection to property and family and housing and development and other things, but you've got this risk of insecurity of title. Now, so I wrote this article called No Sticks in My Bundle, which I only tell you because if you Google it, it's all there with sites and everything if anyone wants to kind of look into it more. But I wrote this article relatively recently that looked at kind of comparing that baseline tenancy in common structure to the Indian land tenure example. And so again, we start with default rules, freely transferable. We've got this unity of possession, which has its benefits. And then comparing that to very recent interior regulations that really change how co-ownership works within Indian trust land. And so, of course, the trust property, the fractionated trust property, is managed and operates totally differently than the default tenancy in common outside of Indian country I just described. And so some of the ways are, of course, we've got BIA as an internal governance support with internal governance rules, providing recording, providing leasing assistance. Obviously, the interests are less alienable. You have to go through the trust process to alienate, and there's not the absolute partition and exit, the sort of quick and fast get out method, which obviously has tremendous value for land security and for land preservation. But recently, the interior's regulations have changed, I argue, and although it used to be that an individual Indian co-owner had a right to use and possess property. That was the purpose of allotment, right? Was to make Indian landowners possessors and users of the property that the federal government chose, right? Now the rule is that in order to make direct possession of property as an Indian co-owner, you have to get a formal approved lease from the Department of Interior and pay rent to your co-owners. Now, I'm not necessarily saying here that that's a bad rule, but I think it's really important to think about the consequences of a modern rule that says Indian co-owners of fractionated trust property cannot make direct possession without a lease. So as opposed to air property in the South, obviously, where we saw lots of informal and creative arrangements, now even a co-owner's own use of their own property is impeded in this way by forcing it through the system. Now, it makes a lot of sense from a rights perspective of property as opposed to the relationship kind of idea, and it makes a lot of sense in the context of the federal trust responsibility. So I would not want Vince special trustee's job. I wouldn't want to have those responsibilities. But if I did, I could see why I would absolutely want to have a paper trail that tells me who is entitled to be in possession of this asset, who is not, to ensure income to all Indian co-owners, whether they're actively using the property or trying to use the property or not. It makes lots of sense from a financial trust asset protection model. But it really does change things on the ground in terms of what it means to be a real property owner. And so to the extent real property is about this broader set of concerns, our relationships to each other, our relationships to a resource, our values, and our land ethics, this rule certainly puts real property in a different direction and says it's an asset to be protected by the trust status and to be managed by the trust status for financial gain. Again, I'm not saying that one's right or the other, but that's a really significant change, and I think we should sort of reflect on whether that's the change that we want to see, because there are trade-offs. I would also note you could argue that this rule also creates more incentives for relatively passive fractionation, or at least doesn't discourage eliminating fractionation, because if I am an individual Indian allottee, if I do nothing, which is a totally rational choice, I'm an absent landowner, I do nothing, property will get leased, I will get fair market value, and I don't have to make any active effort to either engage in the leasing process or to possess the property, and I get revenue, and that's totally rational. But if I can't ever possess the property, even if I get to, without a lease, even if I get to 2 or 3 or 4 co-owners, or if we drastically reduce the number of co-owners through buyback or other things, it's the incentives to consolidate go down, because even if I get it down to 2, I still have to go through this process in order to make use of the property myself. Now, just a couple of other kind of statistics that I think kind of might be relevant in the analysis as to whether this is the rule that Indigenous people want or not, which again, I don't know what the answer to that is, but in the initial implementation plan for the land buyback program, Interior estimated that from 2006 to 2011, half of all jointly owned Indian land was idle or generated no income. And then more recently, in the 2015 status report, Interior acknowledges that approximately 60% of fractionated tracts with individual trust interests generated no individual Indian money account income. So if the reality is that there is property that is not being used, and we're telling individual Indian co-owners that even if you consolidate down to a few co-owners, you can't make direct possession without going through this very formal, costly in terms of time and effort process, and land is not being used to its fullest potential, it's a hard question about the design of this rule. All right, and so that's what I want to add, at least to this conversation about fractionation, is not just how do we consolidate, but how do we make co-ownership usable, and what does usable mean? What do we want that to look like? And so it's not just the fact that we have co-ownership, but how that co-ownership is organized, especially understanding that we're going to have some degree of co-ownership. It's going to persist. And then the sort of broader question of like, what's the function of this rule and what purposes does it serve and who should decide? Now, there are lots of other models of what co-ownership could look like. I just did the tenancy in common example because it's kind of the state law outside of Indian country standard. Lots of people, and again, I wouldn't sort of speak to this, but so Dean Stacy Leeds, who's a member of the Cherokee Nation, has written a lot about indigenous land tenure, and she's written about, for example, Cherokee traditions of co-ownership, where she says there were preferences for active owners, there were first refusal rights. If an individual co-owner wanted to sell, they would sell it to other co-owners first. There was a consensus requirement for making changes to the property, and it had kind of this organic, natural sense of this is what kind of co-ownership, what the values we wanted to reflect. And those values are very different than a value that says absolute exit rights to partition with a courthouse sale, which is the state law example, and also very different than the values and functions of the system now that says even co-owners need a lease, right? Because we fairly want to make sure we've got economic returns for all co-owners. Okay, so that's fractionation. I want to go a lot more quickly through my last two examples. So for anyone who's looking at the clock, I'm going to start going faster, I promise. I want to say, to think about, so that's kind of, let's think about the system as a whole, not just consolidation. I also think we need to do the same thing in the context of this kind of conversation about jurisdictional checkerboarding. And so let me say, okay, so jurisdictional checkerboarding, I think this is how it's often conceived. It's in the idea of an actual checkerboard, that there are fee properties from surplus land sales and other transactions, especially in the Great Plains where I am, very common, pervasive checkerboarding patterns of fee properties next to trust properties. And as you all know, the jurisdiction changes dramatically based on whether property is held in fee or in trust. And so when it's fee property, there's a stronger claim for state law, also tribal claims depending on the conduct and the owner. And then, of course, trust property is to the exclusion of state law, and it's federal and tribal, to some degree tribal. Now, that, of course, this kind of checkerboard problem is important for zoning, land use, kind of who has authority, how do we govern these broad spaces, especially with overlapping jurisdiction or even uncertain jurisdiction as to particular places. Now, I want to just think about how I would argue that the jurisdictional checkerboarding is even sort of deeper than that and more important than that. And so the next two examples that I want to talk about are really about this kind of complex relationship between property and sovereignty in Indian country. And so property, although sort of one construction of property, of course, is this individual autonomy idea. It's the idea that it keeps me free from the government. Whether you sort of have a sense that property came from before the politics or after, or sort of the origins of property, like that's a whole different conversation. But in any frame, property is enforced by government action, is defined by government rules, and depends on government support in order to be reflected by co-owners and non-owners. And my neighbors don't go onto my property because the state supports my right that the property ends where I say that it ends, right? So sovereignty is very much related to property, and in that sense, it sort of also adds to this idea that where we set property rules matters because it is a government act, and so it should be sort of just and in the public interest in the way that any government act should be. But also in reverse, property in Indian country has a very different relationship to sovereignty in the sense that individual choices about property impact or decide who has jurisdiction in that jurisdictional checkerboard framework. And so outside of Indian country, property jurisdiction is based on territory. I live in Nebraska. If I bought property in Iowa, Iowa would have jurisdiction over my property, no question, because it's within Iowa's boundaries, and they would define my property rights and regulate my property rights, and I would be subject to Iowa law even though I'm not a citizen of Iowa. Now, that, of course, is not how it works in reservations in Indian territories. now, and instead it's much more complicated. And so 2 examples that I just want to kind of add to this conversation. So first is just, I'm going to talk about emulsified property, and then I'm going to talk about hypercategorizing property interests. So emulsified property is this. It's the idea that although we construe the jurisdictional property interests as box by box by box, by parcel by parcel by parcel, there are actually many examples, which I'm sure a lot of you are familiar with, where within an individual parcel, we've actually got mixed tenure status now. And I call those emulsified because it's a mix of trust and fee ownership. And so instead of this sort of traditional frame of we've got a trust property next to a fee property, if we are more accurate, well, we would also note that there's differences between individual trust and tribal trust. Different rights and remedies and responsibilities and entitlements come with whether it's an individual trust status or tribal trust status. And then, of course, fee is also more complex because jurisdiction is different depending on whether it's Indian-owned fee, maybe citizen versus non-citizen Indian-owned fee, tribal fee, or non-Indian-owned fee. And there are different jurisdictional outcomes with, of course, the state having the strongest claim as to non-Indian fee, the tribe having the strongest claim as to Indian-owned fee, and then when we're up in the green, the federal trust status, of course, significant federal authority, but also some tribal. Now, again, emulsified property is just the word I'm using to talk about this phenomenon that's actually, it's more prevalent than I think I thought it was. But frankly, this is an article, so it's called Emulsified Property. You can also find this one for sites and things like that. Tell me all the things I'm wrong about, that would be great. This is, when I was at OHA doing Indian probates, I remember, decedent A would have undivided interests of 2%, 3%, and 4%, and she bequeathed them to her non-Indian spouse. And so we would pass those undivided co-ownership interests that had been in trust to a non-Indian and a non-IRA tribe, and then those would automatically go out of trust and into fee. So this is the rule that when a non-Indian becomes owner of what had been trust property, Interior says it's a ministerial act of converting the trust title to fee title. By transferring to non-Indians, you end up with fee status as opposed to trust status, kind of automatically and often kind of without necessarily being aware of all those consequences. Well, when we've got fractionation, when we've got a whole bunch of co-ownership interests in individual properties, and one person, either through intestacy or devise or gift deed or other ways, passes their property to a non-Indian, then that undivided trust interest becomes automatically an undivided interest in fee, which means you have a trust co-owner with an undivided interest in the whole, and also a fee co-owner with undivided interests in the whole. Now, that is a jurisdictional amazing problem, I'm going to say positively, right? But I mean, it's a nightmare because you have undivided interests on the physical property. You cannot distinguish where the fee co-owner is as opposed to the trust co-owner. But maybe you have different jurisdictions defining those undivided interests. And as we just saw, state law, tenancy and common law, federal law defining an individual Indian co-owner's rights, those are very different. Those are not congruent systems of co-ownership. And so what happens when they're emulsified or swirled together, marbleized together in one piece of property? Now, a couple of numbers. There's actually lots of, Interior, of course, does not keep records of any fee interests in property, and so Interior does not record who owns the fee interest or necessarily even know who owns the fee interest. Office of Hearing and Appeals would issue a probate decision, tell the non-Indian new owner, you are now an owner in fee, and then it's on that non-Indian owner to record their fee interest in either state or tribal, if there was a tribal recording system, but typically in state recording systems now. And then to probate that undivided fee interests in state court or tribal court, if there's a tribal probate court, and go through state law. Also be subject to state tax on that undivided interest. Now, so these emulsified properties, they've sort of been acknowledged in lots of places, but we don't have great data about them because they are recorded in different institutions, different governments. That 1992 GAO report I talked about earlier, it does talk about, it actually, it's just in a chart, okay? So it doesn't talk about all these jurisdictional problems. There's just a chart, I think it might be table 5, I'm not totally sure, I think it's 5. And they say, well, we're just gonna look at who owns these interests. And GAO said, and only 56% of fractionated parcels is it all individual Indians who own 100%. But in 44% of tracts that are fractionated, there's some mix of undivided ownership, and it could be individual trust and tribal trust, which has different rules, and there are differences there, which is interesting for the buyback, and we could talk about that as well if we have time. So 44% have some mix, but of those 44%, 20% have a non-Indian co-owner in fee. So this is in 1992, 1 in 5 fractionated tracts have at least some ownership interest that is outside of the jurisdiction, arguably, of the federal government, questionable jurisdiction of the tribe, possibly different jurisdiction of the state, and this whole kind of mess of how do you actually make this work. Now, Thomas Stratman, who again couldn't be here, he beautifully updated that table 5, which it is table 5 in his paper. Again, doesn't really talk about sort of why this is a problem, but does give more data about the degree to which we have mixed ownership, mixed tenure status ownership. And so he says now, and this is probably because of buyback efforts, but although 2010, maybe not, maybe exchanges or something else, but 60% had mixed ownership, either tribal and individual or tribal, individual, and non-Indian, and 30% had a non-Indian co-owner. So 30%, it's gone up, right? 30% of interests now have a co-ownership interest by a non-Indian in fee. And so actually, if we were thinking about a jurisdictional checkerboard, it's much more complicated than just green square, white square, fee, and trust. There's these different types of trusts, and then we've got these emulsified kind of mixed ownership properties. Now, I can, again, talk more about this, but just to kind of put the placeholder here, there are lots of challenges for landowners who want to make use of what I'm calling emulsified property because there's a lot of uncertainty about how these respective rights get defined in relation to each other. And so there's some Interior Board of Indian Appeals early cases that suggest this kind of dichotomy of the undivided fee interests are subject to state law, so that fee owner has an absolute right to possess the whole, probably without a rent requirement, and then the trust co-owners have to go through the federal process. Now there's uncertainty, which I'm also happy to talk about, but I think there's uncertainty in the new leasing regulations, the 2013 leasing regulations, where kind of in one subsection they imply a non-Indian co-owner does not need a lease, and then in another subsection imply that they do. And even if the fee co-owner does need a trust lease, that's also problematic because then you're saying the fee co-owner has to get a lease from trust co-owners from a leasing process that they don't get any of the income from, they're not included in the lease, and they don't have a vote or a participation stake in how that lease is defined. Now, to the extent there are conflicts, and of course there are conflicts among co-owners all the time, but when there are conflicts in emulsified institutions, we don't have that clear system of a unified dispute resolution mechanism. It's not clear if there's one court that has jurisdiction over ouster claims or waste claims, or there are lots of interesting cases where people have tried to partition these. State court will say we can't partition because we don't have jurisdiction over the trust interests and there's been no waiver of sovereign immunity. Federal and tribal courts might say I have jurisdiction, but they're kind of unclear about their jurisdiction over the fee interests. And so I've talked to attorneys who say, we've tried to, we don't know what to do. These are just kind of stuck and there isn't a clear unified dispute resolution mechanism. Uncertainty, risk of regulatory error, there's also cases where someone who wants to develop the property says, I'm going to comply with county regulations for timber harvest because I think this is a fee interest and that's what I'm doing. And then Interior, probably rightly, says, no, this is trust as well, and so you have to follow trust processes. And then you end up in trouble, right, for making the wrong calculation about who regulates what in the face of lots of uncertainty. Now, there's also risks for the whole community about having this emulsified co-ownership. One is that I think a lot of these properties are probably just not used, because if I was a person who wanted to lease property or develop property, if Interior could tell me who 50% of the owners were, and I don't know who the other 50 are, and maybe they're not recorded in state recording institutions, I'm not sure about what those state co-owners' rights are versus tribal trust owners, it's a risky endeavor, and so property probably doesn't get used as it should. Now, there's also a risk of state tax foreclosures, which would make the state co-owner in an allotment, which is obviously crazy and problematic, but a possibility. And I've seen examples of tax foreclosures of these undivided fee interests. Lots of just inequities in the fact that this exists and we haven't, I think, fully explored it. Happens kind of automatically without a lot of intent necessarily. And let me just say, so I do think that there's kind of interesting questions about, to the extent the buyback program is not, fairly, and everyone acknowledges, not going to get absolute tribal control of lots of these tracts. Well, then we end up with, someone asked a question about Navajo, of a similar kind of scenario where you have tribe as co-owner in tribal trust with individual co-owners in individual trust status. Now, a lot of those conflicts have been worked out, but it's interesting that, in the new leasing regulations, but it is interesting that, at least historically, there are instances in which Interior would say things like, it's not a good idea for an individual Indian allottee to be a co-owner with a tribe, because how do you get consent from a tribe? That's just more sort of difficulty to do that. They have sovereign immunity if the BIA can't consent on their behalf, if you're in a situation of conflict, if there's some impairing of individual rights by this mix with tribal trust owners. But I think even more importantly, and what I just want to end on here, is that the buyback program, which is obviously, doing a lot of good work in terms of consolidating interests, it's only applying to trust interests. And a lot of our probate sort of consolidation strategies, one of the first slides I put up, those are all specific to the trust co-ownership interests. And the undivided fee interests are largely seen as outside of Interior's jurisdiction or outside of federal jurisdiction. And so we've kind of missed them in our conversation about consolidation. And my purpose for here is to say, again, the same theme of, if we're thinking about the whole system as a whole, we've got to address all of this in some comprehensive way, because otherwise this just persists as an unaddressed issue. Now, the last thing I want to conclude with is just a quick sort of review of a couple theories as to why we're maybe not fixing this, or it hasn't been fixed. And one is that this is just really complex, right? And I just sort of illustrated for you how complex this is. Super dense regulations, highly technical. APRA is nothing if not technical. Jurisdictional differentiation, the fact that we've got all these different decision makers, and indeterminacy. There's a lot of uncertainty about how this actually works on the ground. Now, those are the four features of legal complexity. If we look at law and try to put it on a spectrum of if it's really complex or not very complex, Indian land tenure is basically poster child for legal complexity. Now, there's also some good scholarship about what it means to have legal complexity, like why we would worry about it. And it's got actual costs. So one is that as things become more complex, stakeholders rationally withdraw. So a landowner might not go to the trouble of consolidating if it's a very complex system to navigate. Democratic failures, I think the BIA does great work in lots of cases, but certainly the high level of administrative expertise that is required to manage such a complex system keeps the BIA in business, right? And so, and sort of people don't appreciate all the complexity, and so therefore these decisions get made that maybe the stakeholders aren't fully consulted or aren't fully engaged in that process. And then, of course, if it's so complex, one rational reaction is to say, hands off, I can't predict how making a change here is going to impact all these other things, and so our reforms end up being deficient, or we end up not making any reforms, which you might argue, for example, the exclusion of undivided fee interests from things like the buyback would also be relevant to that. Now, I just want to go, this is my third, I'm done, my third final example of sort of another kind of layer of things at issue here. And one is that, actually Kristen kindly covered some of this for me, so I don't need to talk about it as much, but the other phenomenon that I'd say that I see when you look at the whole system is that we often look at efforts for, especially federal reforms, that are advocated or intended even to increase local landowner control, tribal self-determination, tribal self-government. And when you actually look at those reforms, what we actually see, however good intentioned they may have been, that as a system is so complex, what we actually end up doing is just making things more complicated with each sort of little iteration. So Kristen talked about kind of the risk of just constant experimentation. I mean, another risk is that we just make things more and more complicated. And so the permanent improvements is an example of where we've had jurisdictional checkerboarding, we've had emulsified property, and now we're creating like even more minuscule jurisdictional differences based on property interests. So not general sovereignty, but instead individual determinations as to whether something is a permit or a lease has dramatic sovereignty consequences that we don't necessarily understand or reflect in individual decisions. So the permanent improvements is one example. The fact that many permanent improvements are considered fee property. Now, I would add to what Kristen said, so of course this does create problems in the same way that the emulsified property I talked about before does in terms of what if there are different possession rights? What if you have the right to possess the house because it's fee property and you have an undivided absolute right to make possession, but the house is on trust land, and in order to possess the trust land that you co-own, you've got to get a lease, right? So we multiply the burdens of co-ownership by this kind of vertical separation of trust statuses. Now, another interesting thing about the permanent improvements issue to me is that when Congress said, well, okay, so we acknowledge we also have a problem of probates, that if the permanent improvements are in fee and the land is in trust, then not only might you have different rights to those properties, but they're going to pass through different property systems, and state probate might say, this house goes to A, and then APRA will say this land goes to single A or B, right? Or there would be you could have different probate results based on different jurisdictions. So Congress said, well, we'll fix that by making permanent improvements pass, although they're in fee, but subject to the same intestate distribution or rules of APRA. But they didn't actually give interior jurisdiction to do the probates of permanent improvements. And so what I understand is happening now is Interior and OHA will say permanent improvements per this regulation and this public law pass just like the trust property. But now you, owner of the permanent improvement, have to go to state or tribal court and separately initiate a new probate in order to pass that house, that permanent improvement. So when we're trying to kind of simplify, we don't actually simplify because we bifurcate jurisdiction even more complicatedly. Same with the Indian versus non-Indian differences. Now, obviously, there's been a lot of history about who can hold property in trust. I would just note that some of the sort of new innovations of things like the eligible heir status, but especially the special non-Indian life estates without regard to waste, bifurcate possession from title even more. So they fractionate possession by having a life estate tenant and a remainder tenant, a remainder holder. The life estates are complicated because we've got this special without regard to waste, which is a novel, technical, hard to understand, pretty strong entitlement for the life estate owner. And then lastly, this kind of property right versus property right difference. If something's a permit, the new leasing regulations make clear that this is sort of, again, in the spirit of more self-determination with property. If it's a permit, then it is not subject to the tribal leasing or the federal leasing regulations. You do not need BIA approval. BIA does not manage the permit. But if it's a lease, then you're subject to tribal or to the trust system, and as a co-owner, you must make use of your property. So whether you structure something as a permit or a lease, as a landowner, has dramatic consequences, and you get to essentially pick, right? This is not really, because there are actual categorical differences, but a permit, non-possessory short-term use right, usually revocable at will of the landowner, that's subject to tribal law. The lease, landowner makes that decision, enters into a whole different sovereign sphere, a whole different jurisdictional sphere, and is subject to federal rules. Also, this assignment versus alienation, we see this issue. There's lots of talk, I think, about tribal assignments and sort of hope for better systems of tribal assignments after the tribal land consolidation, as tribe becomes landowner of more of the land base, assign more of that property as a way for individual use and possession of property. Now, whether what the tribe does gets characterized as an assignment or a conveyance has dramatic consequences. If it's a conveyance, it needs, of course, federal approval, congressional approval, and secretarial approval under current federal law. If it's an assignment, BIA says not in our jurisdiction, that will be subject to tribal law. Now, there was a recent Ninth Circuit case that I'm sure some of you are familiar with, but it's the Kemawave tribe versus Jewel, and that was an example of the tribe trying to make near perpetual assignments to individual tribal citizens as a way to encourage them to build houses and relocate to the reservation. And the Ninth Circuit said that looks too close to a conveyance, that looks too much like an alienation. And so even though you did that as an assignment, it's actually subject to federal law, and federal law doesn't authorize it. So it was no more. So again, that kind of minute difference based on what property interest is at stake determines jurisdiction, as opposed to anywhere else in the world where we would have territorial jurisdiction over property. What I just want to end with then is, well, that's lovely, right? Because I can just make problems and then sit down. But that's not actually what the purpose of this is not to just say, like, wow, it's even harder maybe than we often think about. I'm sure you all appreciate a lot of these complexities already. But what I would say is that if this is our property system now, if what we have is a chimera, what do we do about it? And I know that there's a lot of historic conflict. Professor Hershey talked about reconciliation here. I mean, there's different interests in terms of tribal nations and individual allottees. But if the choice is local self-determination of what a property system should look like, or federal trust status top-down system, the one strong opinion I have is that I don't think the federal system has done a very good job, right? And so if we want a property system that reflects more local values, then we might need to have a conversation about more tribal sovereignty and iterations of more local property norms. So this is the Harvard project, which is obviously a friend of this university, on American Indian economic development, finding that tribal self-determination, tribal decision-making obviously far outpaces external decision-making in nearly every instance. The Department of Interior has also acknowledged that recently, saying that tribal sovereignty, even in the context of leasing regulations, that tribal sovereignty is really the better way to go. And so what do we do with that? It's really easy. I think tribal sovereignty is a big word, right? Local control, those are big words. Much harder to implement, especially when you've got settled individual expectations about property. It would be hard to just come in and say, today we redefine everyone's co-ownership rights to their trust allotments consistent with these tribal values, and now what you thought you owned, you actually have a different set of ownership. Now, that doesn't seem like that's sort of a non-starter, right? To just sort of all of a sudden superimpose a new property system. But I do think that there are kind of iterative steps that we could work on towards improvements. And so part of it is just defining what the goal is, which is why we started with the functions of property. And then it's understanding all of the incentives and complexities of the way the current system operates. And then I would argue it's making room for small, iterative efforts of creativity, innovations from landowners, exercises in more free and flexible experimentation as steps towards improvements. And this will be, I'll end here, and I have just a couple more slides, but there's actually a whole science of complexity that looks at how complex systems operate, whether it be natural resource management or how we address things like climate change, things that are really messy. And we think, how do we solve the problems of greenhouse gas emissions when there are all these different countries and all these different things happening at once? American Indian land tenure feels to me kind of that caliber, that there are lots of hard interests, people who care passionately and have strong views, lots of different decision makers, and including individual landowners who are making decisions based on this is a permit or a lease, this is who has jurisdiction or this is who doesn't, and this it fractionates or it doesn't, right? There are these sort of all these different actors. So what complexity science says is that the way these really intricate, complex systems operate is from a bottom-up way, and that the way that complex systems adapt over time is by leaving the flexibility, the space, the informality, the platform for small level experiments that we can learn from and then build themselves up. And certainly individual landowners are doing things like this. Tribal allotee organizations, land exchanges are doing this. But I would sort of gently suggest that perhaps the system is still too rigid to allow enough of that. One of the, Frank Pommersheim talks about sort of the most terrible effect of colonialism was the lack of flexibility of choices, the taking away of choices. And so one way we might approach the Indian land tenure problem is just to think about how can we kind of slowly, iteratively re-embrace the flexibility of choices. This is also from complexity science, and what I think is useful here is that, so this shows this cycle that different systems that are complex go through, where they adapt, they experiment, they fail, they sort of do better and have this reorganization process. But there's this point in which complex systems can get trapped in this top right corner, which is called the rigidity trap. And it's where all of the incentives are so in line that flexibility and experimentation gets paralyzed. And I think it's not too far removed to at least think about whether we might be in something like a rigidity trap now, and the ways in which complexity of the system itself is just reinforcing the system that may not be what we would desire. Now this, I think is, I have maybe 2 more slides, the science of complex systems. So this is the idea of a panarchy, which this, I think, is the most important concept. So, and this is the tentative part where I'm still learning. I do not know everything about complex. I don't even know a little bit about, I know a little bit, but there's a lot more to know about this. But the way I understand it is that when you actually look at complex systems, it's not just one loop of experimentation and reform and reorganization and building and growing. Instead, it depends on these several nested levels. And so you might think about in the law, kind of the highest level being like the most slow to move, the slow, steady, something like the Constitution, right? As like that, we don't change that very often. That's pretty steady, that provides stability. And then in the middle, we might have statutory law or regulations or state law or tribal law, tribal custom, kind of middle level decision-making structures that there's some stability, but not as much, or there's some stability, but less than like a constitution. But then what's really critical is this bottom level, which is the small and fast, right? Is the idea of local experimentation. And small local experimentation then feeds up and informs, and you experiment and it goes well and it feeds up and it changes law, or it doesn't go very well and then it sort of, that informs us that we don't sort of do that. And there's these sort of interactive effects on each other. And so what I would argue is that there might be little cracks in this pretty rigid structure that we've got, where there's at least opportunity to exploit more flexibility and to do more experimentation and more innovation in a way that really matters, right? Because I think this really matters. So this is a list of kind of relatively like easy, not easy in the sense of easy to do, but like clear jurisdiction versus things get harder. And certainly there are some existing landowner tools to make use of one's property, whether it be through like the permits, for example, a permit use on property, or tribal assignments. Like these are all areas where there's pretty clear tribal autonomy, local landowner, more autonomy, and the ability to be kind of a little more innovative. And then it sort of goes into things that get harder, right, that are harder for tribes to do because of legal structures, because of just the kind of things they are, right? Like property tax is a hard thing to do. But they're all opportunities in which, if we sort of paid attention to, they're opportunities for local control to grow and for local, through tribal government institutions, through landowner groups, through landowners themselves, to kind of experiment and find the ways in which property might meet functions that are more reflective of the functions you want them to meet. And I would just end with, now these are just normative ideas, because again, I would not put myself in the position to dictate or even suggest one way or the other, but these are some things that we might think about. So what if, so the co-owner quorum rules, for example, or other active preferences, if what you wanted was a co-ownership institution that actually encouraged landowner engagement and actually encouraged owner use and owner participation, so that we wouldn't have statistics like, the Arizona agriculture statistics are amazing, but in the rest of the country, it's something like 16% of income and outputs from Indian agricultural land go to Indian people, and the rest is all to non-Indian lessees or otherwise not used to its full potential. So, I mean, we have sort of this potential for growth by more Indian use of Indian land. And so you could do things like assign leases, vote on leases, decide who gets a lease based on the people who actively participate, right? On the sense of like, almost like a quorum rule. Like we would want the people who are actively engaged in the property to get to make a choice, and then they bind the people who choose not to participate. You could also use tribal law or local norms to set, like, what does waste mean in the Indian land tenure context? What are the kinds of uses of these resources that we want to see as a people? And we could set those, and through that, start to reflect values that matter to us. And then you could also do things, lease priorities. So right now, an individual co-owner of Indian land has no priority as a matter of federal law, even in a lease bid, right? In a fight for a lease, the co-owner has no preference over someone else. You could change that. You could say, if somebody matches, we want co-owners to be able to use their own property, right? And some tribes do that through like agricultural management plans and things like that, but you could do it more. Dormant interest limits. So there's sort of other consolidation strategies that would reflect sort of values. If a value was we want people to be active, people have talked about, well, what if you, and I have talked about, I don't know who the people I have talked about, undivided fee interests. Well, if you could argue that there's tribal jurisdiction, could you make a registration requirement? Could you make undivided fee co-owners register in a tribal registration office, or impose a tribal property tax on that undivided fee interest? There's lots of legal issues there, but I think it's not outside of the realm of possibility. And then if those people are absentee or not recorded or have lost touch with the property, then that's a way to consolidate that ownership back. And then there's actually a mandatory trust acquisition from there if an Indian becomes an owner. And then the last is perhaps most sort of controversial, but you could ultimately move to a system where trust land transactions were dramatically more flexible as between Indian people. So intra or intertribal, depending on how sort of you choose to set that standard, you would let tribal norms and tribal court or local rules dictate sort of if there's a speculative or an inappropriate or a fraudulent transaction, and the things that you might be trying to protect against, you could do that through other mechanisms that wouldn't sort of tie up the whole property system. So you would allow more free and flexible transactions, at least as between Indian people, because then you don't have any of the risk of land loss or loss of trust status or the jurisdictional consequences that might come from that. All right. I talked way longer than I thought. I'm sorry about that. But I have my contact information here. I would love to hear from anyone who's got reactions or thoughts to the stuff we talked about.
I have a question. I'm not sure where I want to start, but that certainly is a lot of information, and I thank you for that. One, I'd like to ask, in the area of complexity of choices that tribes can take advantage of, given that I'm with the Navajo Nation, in order to empower individual self versus the tribe, how would you suggest that we change, say, perhaps laws or policies in thinking about what the question was asked earlier? What do you intend to do with the buyback land that's given to? One, I know we go through a lot of reorganization in the tribe right now. I believe that's what we're headed for, and reorganizing our nation again. In terms of taxing individuals, and given that the property laws are mostly under the Bureau of Indian Affairs, so what are your suggestions on how the Navajo Nation can start to approach change in the way that this property is going to come down?
Yeah, I mean, that is the million-dollar question, right? That's the hard question that I don't have the answer to, because I think the answer is probably different for each Indian nation and each community based on specific circumstances where you are. And obviously, trust takes a long time to build. And individual landowners, a lot of individual landowners that I've worked with, are highly suspicious of lots of things that change their property rightly. And a lot of that is not tribes' fault. A lot of that is because of federal history and true experience. And so in some ways, that's why I don't suggest starting with property tax. I don't suggest starting with new obligations on individual co-owners that feel like they are sort of large, drastic changes to the way things currently are. But I think what we're talking about is this process of tribes asserting more jurisdiction, more sovereignty, more determination over property, so that it's not just a matter of federal property law. And so whether that exists as, some of the things that you mentioned earlier sound tremendous to me, of educating landowners about the things that, what their rights currently are. And the local governance kinds of things that the Navajo Nation have. You're far ahead in some ways for that. But I do think there's more jurisdiction to assert. So, it could be in the context of regulating permits. It could be in the context of defining tribal assignments and the process for which those will work. And so this is intended as like a kind of start at the top and work your way down, at least very generally. The other thing I would say, I pass through these relatively quickly. I actually do some other work outside of the Indian land tenure context on participatory models and land use planning, and I've actually done this grant with colleagues in the United Kingdom, where Scotland is a really interesting example of a very developed country that has very recently had hard political conversations about the kinds of property rights that they want their society to have. And so Scotland has recently enacted reforms that include things like, they call it the right to wander, where you have a right to access private property for the purpose of enjoying a walk in the country. They've got some buyback things where individual community groups can buy back interests. So things that seem like relatively bold changes in well-established property systems. And what I have noticed is that it was a very participatory process, and so there was high degrees of conflict, but they had a lot of sort of momentum from the ground up of landowners who wanted these sorts of changes, citizens who wanted these changes, and they had lots of conversations about it. So this is actually, I don't think this is not a perfect fit for Indian country by any means, but this is a model. There's actually a website that I'll just tell you now. It's called RUFKIT, RUFKIT.org. And it is a kit that we developed out of this grant where you actually create simulations to talk about property issues. So I actually used it with natural resource districts in Nebraska, where upriver and downriver groups had conflicts about use and quality of water. And we used this tool to create basically discussion simulations. And we found it really helpful to talk not specifically about the actual water issues, but something very close to it. And we're able to facilitate some really good group conversations about land use. And so that's a tool that we've worked on that it's pretty European, I think, as you look at it, pretty specific to UK systems at this point. But it could be adapted, and maybe it's not in the form of a simulation, but sort of tools for participation and conversation about it seems critical to me as well.
With regard to Navajo, this takes some of the federal secretarial approval out of the equation. Navajo, for example, has like a master leasing arrangement that was approved by the Secretary of the Interior. So certain types of leases do not have to go through the Secretary of the Interior by virtue of, as long as they're under, I think, 25 years. And there may be room for a 25-year extension.
And
So
that's just for tribal land, though, right?
and that's just for
Yeah.
tribal land. But that depends if the tribe acquires a 51% ownership in fractionated lands too. There's also a project, a non-native project called Dreaming New Mexico. And they took into account all of the energy, all the farming, the ranching, everything that was pertinent to New Mexico. And I've often suggested to Native societies that they conduct their own, so that not only are you dealing with fractionated interest and land tenure, but the discussion of land itself encompass more, like Dreaming Navajo, Dreaming Hopi, Dreaming whatever community there is. And so if those of you that want to take a look at Dreaming New Mexico, you could Google that and see what kind of totality of interest that were considered in designing that. And there's a mapping to it as well. I do have one comment as well. When you map and when you articulate and you define, and this was, I think, one of the most inimical things about the Jeffersonian model of meets and bounds and dividing things up into this type of land tenure, especially promulgated by the allotment period, which still is sustained today by the courts, even though it was a doctrine that might have been repudiated over 100 years ago. It still finds its way into kind of the, if you will, the federal corruption of continued Native American sovereign interests here. Again, that is something that always has to be challenged through education. So check out Dreaming New Mexico as well.
And I added that website too for the toolkit.
Any,
models and so forth that you mentioned in the presentation?
Yes, you absolutely can. If you can actually get it now, and I can send it to you too if you give me your contact after. But the No Sticks article and the emulsified property article are both free on Google. So if you just Google my name and then the letters SSRN, you'll go to my page and they'll both be up there.